When, as an advocate, we start the practice in the court, that time we don't have face value, and sometimes we feel uncomfortable because the case is very strong and we are new in the field. So, how to get the relief in the court and how to produce yourself in the court so that you should get justice for your client. First of all, whenever you appear in the court, you should come in a proper uniform, normal and well prepared with your all dress up and sense. And after that, whatever you have in your mind, like you have come for anticipatory bail or you are fighting in a case, you should be ready for at least for the same day lesson. It is not necessary that you should know all the case properly on the same very day when you appear for the court on the very first day. You should be ready for the same lesson. Suppose you have filed a Hindu Marriage Act case, Section 9 of HMA. The first day is only for notice, so need not to worry. You have to appear and you have to just uh, uh, be normal situation and always turn your head down when you saw the honorable court, and then you can mm, ask for the date from the reader. There's no problem. A reply is also very simple, that you are going to the court and asking the reader for date and depositing the reply of the petition whatever you filed. You have to uh, give you date for another reply, or you have to file on the same day, because as per new law there will be short of time for filing the case, and after that fighting the case they have number of months only. So you have to be very cautious. If you get the date and you have time to preparation of the replies, and you should talk to your senior, or you can see the videos, you can see the draft where you can make the reply of the petition. Is very simple, it's not very difficult. The option which you are not denying, you say I'm not accepted, wrong and denied, wrong and denied. And if you want to give the reply, then you said the this para is true to the fact of knowledge, as is the para is illegal. If it is illegal, then and then you have to mention the details whatever your client, you have to sit with the client and ask what the details, and simply you have to mention in the detail. Being an advocate, our drafting is not so bad that we cannot make a reply. You have to make a reply and you can produce in the court. And while going to the court, you have to make two sets you have to given in the court, and one set you have keep for your future reference for as a reference or in the file. But if the petitioners and respondent are more than one or two, then you have to make for each respondent you have to make two sets. If there are two, then you have to make four. If there are three, then you have to make six set accordingly. And after that, when the matter go for argument, you have to be well prepared in the argument, and you have to go through the file also, where the respondent has given the witness also, evidence also. Then you have to study the evidence also. You have to know those points which are you feel that are comfortable with the petitioner and against the petitioner, and then you have to find out the ruling in the high court ruling in the library, or supreme court ruling in the library. Even you get now, you can get in mobile itself, and you have to be well prepared with all the rulings, latest amendment in the act and ruling accordingly, so that whenever you go for an argument, you should be ready. And while doing an argument, you do very simple argument, like a story you're telling the truth to the honorable court. The argument should be short and brief, not to repeat the same sentence again and again. And then you have to talk about evidence, and where the evidence are wrongly given, or you feel that there is some objectionable evidence, you can note down and you can highlight those two or three lines to the honorable court. And after that, you can do the argument regularly. And if you feel that you are uncomfortable while doing the argument because it is initial state, then you can always request the honorable court for either in giving an application that should be allowed to give you written argument, or you can verbally request the honorable court that you want to give written argument because you feel uncomfortable. Most of the time, you should always ready yourself when you speak to the truth. And while before going once you started going to the court, you will understand the psychology of the honorable court also, and based on that you can prepare your arguments such well in time. Sometimes the judges are very lenient and soft. Then your argument should be in argument you should be emotional masala also, and you can put logic masala and legal views also, so that if there is a hitch from other side, learner counsel, opposite counsel objection, then you should have legal point also, so that you can define them properly. And lastly, there should be an uh, there is a high court judgment or high court guideline or supreme court guideline, which you can study few lines, and you can hand over the photocopy, two sets, to the honorable court, so that uh, your whatever you case represent and you fighting for, there should be a strength in the case and you able to win the case. I hope you will like the information, productive. If you feel so, you can use it for your reference. Thank you so much to listening to me. Regards.